Next, we can take Aaron Thomas.
Okay.
And Your Honor, after speaking with Mr. Thomas, he was not comfortable with me signing the rights form on his behalf, and he would like to have an arraignment in person.
And that's fine. Can you hear us all right, Mr. Thomas?
Yes, sir.
All right, very good. This is 3A757954 and 3A757955. When can we arraign him in person, please, Carrie?
Your Honor, due to the holiday schedule, the earliest would be December 7th at 2:30.
Okay, Mr. Thomas, write down December 7 at 2:30 and confirm when you've done that.
Okay. 1 second here.
No problem.
Yeah, I got my phone stolen last night, so I gotta do it on my computer here.
Yeah, no problem. Just let me know when you got that in there.
All right.
Did you get it in there?
Not quite yet. I'm opening up.
Okay.
Before we dive in, brace yourselves. Today's docket features not one, but two sovereign citizens making a mess of their court appearances. From pretending they can appoint judges as trustees to talking about exemption accounts. It's a wild ride of misguided legal theater. First, we meet Mr. Aaron Thomas. He can't even type a date into a computer. And then we head over to Zoom court for Frank Mitchell, a man convinced he's cracked the legal matrix. This episode is packed with confusion, cringe, and courtroom reality checks. So grab your popcorn, because you're about to witness how not to represent yourself in front of a judge.
Okay. You said December 7th at 2:30, correct?
Right.
All right. Yeah, I got you.
And it's here at the Bothell Municipal Court, Mr. Thomas.
Okay, thanks. All right. Yeah, I got it down.
Thanks so much for writing that down. And keep that, don't erase that. That's your notice now. You got an actual notice, right?
Well, oh yeah, I mean, I have it on my computer here.
Fantastic. Thank you, sir.
Hey, I hope you have a good day.
The court's found probable cause for the prosecution is charged, so subject to you and your lawyer readdressing this, you to be here on time for all scheduled hearings, commit no criminal acts, don't drive until you have valid license and insurance in your pocket. Any questions about all that?
No, I wasn't driving though.
Good. Please don't unless you have license and insurance in your pocket.
I would
Right.
never drive. Yeah, I would never drive.
That's fantastic. Glad to hear it. Thank you, sir.
You're welcome.
All right. Next case.
Okay, cool.
You'd think writing down a court date would be the simplest part of appearing in court, but no. For Mr. Thomas, who claims his phone was stolen and struggles to type on a computer, it's an ordeal. This isn't about tech skills. It's about accountability. The court's clear. No license, no insurance, no driving. And when Mr. Thomas responds, I would never, it's almost comical. In sovereign circles, it's always, I didn't drive. But somehow, the ticket says otherwise. Just wait. These small moments of denial are red flags for bigger legal delusions to come.
For the record, I am the beneficiary of the Frank Anthony Michaud Jr. estate. I am the authorized representative, and I appoint you, the judge, as the trustee.
And here it is, the classic sovereign citizen opener. I am the beneficiary of my estate, and I appoint the judge as trustee. This line is straight out of the Sovereign Citizen 101 playbook. They believe the courtroom is some kind of trust arrangement, and by assigning the judge a role, they're somehow flipping legal power in their favor. Spoiler, it never works. Judges are wise to this nonsense, and all it does is signal to the court that you're not serious about addressing the charges. But don't worry. Frank's got more gems up his sleeve.
Good morning. My apologies for interrupting your breakout, but I want to get some of the matters that are already on screen and ready cleared out. Mr. Sullivan and Mr. Moshu.
Ready?
Thank you. Today is the day and time set for the probable cause conference. How are we proceeding, Mr. Sullivan?
Judge, as I was saying earlier, Mr. Michaud has indicated that he'd like to represent himself. Hopefully, if it's acceptable to him, I can remain just sort of present for the proceedings in case he has any questions. My recommendation to him is that We demand all of the discovery in the case. We have paper discovery. I'm forwarding that to him, but we don't have any of the digital discovery. So we are requesting all of that. And then I'm also recommending to Mr. Michaud that we schedule the case for a preliminary exam. And I'm happy to be present for that as well.
Mr. Mohammed?
Yeah, Judge. So I don't believe we had an attorney on record, on file for this case, and that's probably why discovery wasn't sent over. Also, I believe we're missing some stuff as well, and we're in the process of getting them as well. If Mr. Sullivan's going to be the attorney moving forward, we'll send it to him. But if he's no longer going to be retained, then I don't know. I don't think it's useful to send it over to him. So if we can know who the attorney is moving forward, we'll send that discovery to that attorney.
Mr. Sullivan, are you formally making a request to withdraw from this case?
Judge, maybe my request is that we have an adjourned PCC for me to meet with Mr. Michaud and discuss this further, unless he'd like to make a decision just here and now. Perhaps one adjourned PCC and some additional time for Mr. Michaud and I to discuss this. We can come up with an arrangement where I'm at least receiving the discovery, on his behalf and trying to facilitate this for him. But I do want to respect his desires to represent himself.
And Judge,
Sir,
the people would have no objection to any adjournment. And if Mr. Sullivan is the attorney moving forward, please just send me an email letting me know, so that way I can make sure digital.
This back and forth about who's receiving discovery shows exactly why representing yourself in a criminal case is a terrible idea. Sovereign citizens think they're outsmarting the system, but in reality, they're just jamming it up with confusion. Even the prosecutor is trying to figure out who to send evidence to. Mr. Sullivan's trying to help. He's offering to stay on board and guide the case forward. But as long as the defendant insists on playing courtroom pretend, everyone else is forced to do extra legal gymnastics to make sure things stay on track.
Everything that was said.
And was that a reasonable way to proceed at this time? I'm sorry.
Oh no, I still stand as being the beneficiary of the estate and point you as trustee, and demand that this alleged debt is discharged from my account.
This is where things go full sovereign sci-fi. Mr. Michaud brings up an exemption account, a fictional concept pushed by online gurus who sell fake legal strategies. These accounts don't exist, and no judge on earth will ever acknowledge them. Sovereign citizens cling to these ideas because they promise a way out of debt, out of criminal charges, out of reality. But courts run on law, not fantasy. And here, instead of progressing his defense, Mr. Michaud is burying himself deeper in delusion. Sadly, this isn't unusual, and it rarely ends well.
But it's been sent certified mail, and that is me making this special appearance today, and with the challenge of the jurisdiction, since I have not really been fully told, or I really don't understand the allegations or the nature and causes of this.
The defendant admits they don't understand the charges after making multiple procedural demands. It really underscores how disconnected they are. Mr. Michaud sends in a birth certificate and an affidavit making a special appearance, language rooted in sovereign ideology, but can't explain the case against him. The court, to its credit, stays patient and simply resets the hearing. This is what makes sovereign citizen content so paradoxical. It's dramatic and absurd, but also reveals how misinformation online is genuinely harming people's ability to defend themselves in real legal battles.
I'll interrupt you just for a moment. Inasmuch as you've indicated that you don't understand or have not been fully apprised of the nature of the allegations, we will adjourn this matter over for 3 weeks. That adjourned PCC date will be
December 20th at 8:45 with Judge Oakley.
the adjourned PCC date will be December 20th, 2023 at 8:45 a.m. That's in person in courtroom number 2 with Chief Judge Brian Oakley. And between now and then, Mr. Sullivan, you have the opportunity to speak with your client, bring him up to date on the status of these matters and explanation of the charges against him. And if you want to, at that time, have a conversation with Judge Oakley about how you be proceeding or not proceeding as counsel, that would be the time to do it. Is there anything else, Mr. Mohammed?
This closing line is pure courtroom comedy gold. Comparing a judge to a price tag on a can of beans? That's a new one, even for sovereign citizens. These arguments don't just fall flat. They prove the defendant isn't ready to face the real legal consequences ahead. As we've seen, both Thomas and Mitchell have upcoming hearings. And with Judge Oakley on deck, who's known for shutting down sovereign antics, December is going to be one wild month in court. You won't want to miss what happens next.
Anything else, Mr. Sullivan?
Judge, I apologize for the inconvenience, but I am in a sentencing that morning of the 20th. I don't know if does the court have availability like later in the morning. I could make it work late morning on the 20th or in the afternoon on the 20th.
10:45.
That'd be much better. Thank you very much.
Thank you. 10:45 on December 20th. That concludes this matter. You're free to go. You have a good afternoon.
If you found this courtroom drama as bizarre and entertaining as we did, hit that like button and sound off in the comments. What was the wildest part for you? Was it the trustee argument or the mythical exemption account? And don't forget to subscribe with notifications on so you never miss another deep dive into sovereign citizen madness, courtroom chaos, or legal reality checks. This channel is your front row seat to justice served, with a side of popcorn. Thanks for watching, and we'll see you at the next hearing.